Welcome, everybody. Welcome to today's episode of The Law of Self-Defense for Monday, February 12th. 2 days till Valentine's Day. Hope you're all ready, guys. Buy those vacuum cleaners now. I am, of course, Attorney Andrew Branca for The Law of Self-Defense. Thank you. Thank you very, very much. And today we are going to be talking about a hostage situation. I believe it was in New York. Let me just pin this here. And some interesting questions that came up around this hostage situation. Let's see. Open that up there. So we had a man take a woman hostage. He was had her kind of on the ground, sitting, splayed. He had a machete to her neck, hiding behind her from police officers who were communicating with him to relax and not cause trouble. We do have the video of this event. It did end productively for the police and the hostage, and less than productively for the hostage taker. But some interesting questions came up about this scenario, which I intend to address in today's show. Specifically, what if it was you observing this hostage event? Not police officers, you, a civilian, non-LEO, law-abiding citizen, but you carry a gun because you're not an idiot, and you came across this scenario and chose to intervene, and you drew your weapon and you fired a shot, but you kill the hostage, unintentionally, of course. What are the legal consequences there? That's what we will explore in today's show. So hang tight, and we will be back in just a moment. All right. So, by the way, if you're watching this, we are streaming on YouTube, Twitter, and Rumble all simultaneously, as well, of course, on the Law of Self-Defense members only stream. If you're watching this on YouTube, good luck, because this is exactly the kind of show that YouTube suspends midway through. So because we have the video of the hostage taking and there are shots fired and the hostage taker is killed here. That's what we'll be covering. Before we jump into that, though, of course, I have to mention that today's show is sponsored by our good friends at CCW Safe, a provider of self-defense legal services, what many people mistakenly call self-defense insurance. There are a number of companies out there that offer this kind of thing. Some of them are okay. Some of them are great. Some of them suck. CCW Safe is the one I trust, the one I'm personally a member of, that my wife, Emily, is personally a member of. I think they're a great team over there. Do a lot of partnering work with them. So if you're interested in this kind of coverage, I would urge you to give them a look and learn why they're the one I trust by pointing your browser to lawofselfdefense.com/trust. I have a little video there explaining what I find most attractive about CCW Safe compared to their competitors. And you'll also receive there a 10% discount code you can use to save money on your own CCW Safe membership when you sign up. Again, that's lawofselfdefense.com/trust. All right. So let's pull up. Well, first, I should say where I found this. Where I found this video, it's from my good friend, Donut Operator. Awesome dude. Awesome YouTube channel. Trying to get this right. Let's see. There we go. This was his Twitter, and he had embedded the video. He notes it's graphic. Indeed, it is graphic. I should have put a warning on this video, but I'll just do that verbally myself. It is graphic. You will see someone shot and killed in this video. He writes, some of the best shooting I've ever seen by a cop. The shooting was, in fact, very good, very tactically sound. Miami, not New York, Miami 2023, officers received calls that a dude was loitering with a machete in his hand. They showed up to see what was up, and the 38-year-old suspect ran inside a business, taking a woman hostage. The officer in the video waited for the right moment and fired 3 shots, striking the suspect in the face, neck, and left arm. The officer, drew, extended, and fired 3 shots in a little over 1 second. Outstanding. That is outstanding. The suspect's brother stated, quote, "He's a good guy. They can't tell me he had a machete and tried to cut people's throats. Nah, he ain't like that." close quote. Well, we'll see the video. He died, the hostage taker, and Donut will be doing, his usual excellent breakdown of this event on his own channel. So please go to follow him on Twitter at Donut Operator. Just put Donut Operator into the search window of YouTube and he'll pop right up. And subscribe and like and all that jazz. He's a great guy. So that's where I came across this. And then, of course, he had embedded the video in his chat. I've pulled that out for our purposes here. And here we go. So it's a little over 2 minutes long. So there's kind of a, it kind of drags in the beginning. I could have cut that out. It's when the cops are communicating to the hostage taker, trying to get him to just give up. But I wanted to provide a sense of just how long. And of course, the communication started before the start of this video. The cops are already there and engaged in verbally communicating with the suspect. But they really tried to have this conclude without violence. Now, the hostage taker, you'll see at the beginning, is doing a very good job of hiding behind the hostage. So here's that image. Let me do this. He's really, really huddled up behind. Not a lot of great places to take a shot. If you, the knife of the machete, by the way, is held to the far side of the woman's neck here, so wouldn't take much to kill her. He's presenting as an imminent deadly force threat to this woman. Clearly, you might try for the headshot here, but when people are shooting handguns, the most common way they miss their intended point of impact is they shoot a little low. You aim at this guy's head and you shoot a little low, and you've put a round through the hostage, which of course is the scenario we're concerned about here. Later in the video, we'll see the hostage taker begins to expose substantially more of his body and his head. And that's when the shooting officer sees his opportunity and seizes that opportunity. By the way, folks, this is very important. So that officer, I would suspect, had in mind a set of circumstances in which he would be prepared to instantly draw his pistol and fire the shots required to neutralize this threat. And he's waiting patiently to see if those circumstances present themselves. When they do present themselves, he doesn't have to think through the problem in that moment. He's already drawn a red line where, if crossed, he's prepared to instantly deploy deadly defensive force in defense of this woman. That's why his shots are so decisive when they happen. And there's little indication leading up to the moment he presents and shoots that he's preparing to do that. Everyone's acting calmly, everyone's cool, and then the opportunity presents and the officer takes it immediately. So with that said, I'll go ahead and start up this video. By the way, I heard some criticism. There's two officers here. The shooter's on the right, behind the lens of this camera. There's another officer, a black officer on the left. You'll see his hands in the frame. I've heard some criticism of him as if he's unprepared to take action. I don't know if that's true or not, but it's not an unreasonable scenario to have one cop focused on the communication and the other cop focused on taking action when appropriate. It's actually greatly complicates being able to take decisive physical action if you're speaking. The bandwidth, the mental bandwidth consumed by communication, forming what you want to say, communicating it, that slows down your physical reactions. In fact, if you're ever in a circumstance where you're being threatened with a gun and you're thinking you might try to seize possession of that gun in the other guy's hands, you can gain yourself a considerable fraction of a second by asking him a question, waiting for him to answer the question, and the moment he begins answering the question, going for the gun then, because it'll give you a little more time, because his reactions are slowed, because he's speaking. All right, with all that out of the way, let's go ahead and play this clip. 2 minutes, 13 seconds. Fair warning, everybody. This hostage taker is going to be fatally shot within 2 minutes and 13 seconds of when I start playing this video. There's not a lot of gore, but he's pretty obviously mortally wounded. I don't think there's any gore, actually. You'll see like red on the floor, but I believe that's some like a article of clothing. That's not blood. It doesn't appear to me, because we see it before the shots are fired, if I recall correctly. So if you're uncomfortable watching video of people being shot dead by police, this is not the show for you. And I wonder if YouTube has already canceled the show. Not yet. Okay, so that's the warning. Everybody ready? Here we go.
What can we do to help you, Edwin? Edwin. No. Edwin. Hey, tell me. Hey, why are they coming in? They're not going to open up the door. They're not going to open up the door. That's what I'm saying. Well, Edwin, put the machete down, man. Let's talk. Hey, let's talk. We're just talking, man. We're just talking. Please put the machete down. Edwin, put the machete down. Put the machete down. Put the machete down, Edwin. Put the machete down. You're hurting her. Put the machete down. No one has to be hurt here. No one has to get hurt. Put the machete down. What seems to be the problem? What seems to be the problem?
You're afraid. You're afraid.
Edwin.
Okay, well, it's not going to be fair.
Edwin, everything's okay, man. I need for you to relax. There's no, hey, listen.
Watch as more head and upper body gets exposed.
Calm down. Relax. 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 There you go. Just relax, man.
Relax. It's all good.
Just relax. We're going to get this worked out. Everything's going to be just fine. Just relax.
Okay, let her go.
He's not giving up.
Just relax.
Oh, let her go.
Hey,
Okay, let her go. I want her to pull her back, man.
Look,
you need to let her go, okay?
calm down.
Let her go.
Calm down.
About to go.
No, calm down. Hey, Edwin, stop.
Bam.
No, Sally, come on. Come on. Get her up. Get up. Shots fired. Oh, yeah.
All right, nothing else happens after that. So really 1 minute, 45 seconds. But this is the moment the shots are fired right there. I mean, he's completely exposed now from the waist up, right? Which is, of course, center chest, upper chest is where you'd want to place the shots ideally. And as Donut indicated, he was hit once in the head, once in the neck, and once in the arm, which is basically shooting at the center of the available target space from the cop's perspective. So very well done, very quickly fired. And the hostage was not struck. But what happens if you draw your pistol in lawful defense of this woman, which you could do. Defense of others has the same elements as self-defense to the extent that woman would have been privileged to use deadly force to defend herself. And she's clearly facing an unlawful, imminent, deadly force threat in this scenario that would privilege her to use deadly defensive force on her own behalf. Well, to the extent she's privileged to do that, you're privileged to use deadly force in her defense. The same 5 elements apply, except they are applying to her. And that gives you the legal privilege to use deadly force in her defense. So you could draw your pistol and attempt to engage the hostage taker with deadly defensive force on her behalf. Now, of course, one question is, would you want to do that? Do you want to interpose yourself in this conflict? You don't have to. You don't have any legal duty to do that. You're incurring risk, both physical risk and legal risk, by intervening into someone else's fight. In fact, a lot more risk than you are when you're defending yourself. When you're defending yourself, at least you know what's going on. At least you know how you're reasonably perceiving what's going on. When you turn a corner and you see people fighting and you decide to interject yourself, do you really know what's going on? Do you know how that fight started? Who the bad guy really is? Now here, it would be, I think, hard to interpret this as this woman having been the unlawful aggressor somehow. And now what? She's certainly not an aggressor in this scenario when we're watching in the video. So those risks of what I call ambiguity risks in coming to someone else's defense may be very small here. Much the same as when there's an active shooter scenario. You see someone walking around a shopping mall with a rifle, potting people. I mean, there's not a lot of ambiguity there about who the bad guy is. So those risks can be small. That might play a role in your decision on whether or not to intervene in someone else's defense. But of course, there's also legal risk. You could do everything right. You could not hit the hostage and just hit the hostage taker and still find yourself prosecuted, because prosecutors can go after anybody, really. And then you have to defend yourself. So even if you've done everything right, you could still find yourself prosecuted for a use of force event. And if you are prosecuted and put in front of a jury, there's anywhere between a 10% to 50% chance you get convicted, no matter how innocent you actually are, no matter how justified your shots actually were, no matter how effective they were, and harmless to the hostage. So there's a legal risk. That legal risk is never zero. Be a member of law self-defense, and you can get that legal risk pretty close to zero, but it's never quite zero. So you may take the position that, maybe you've got 4 kids to raise, and you're not willing to risk dying in a fight, someone else's fight, or going to prison for the rest of your life over someone else's fight. I think that would be a reasonable position to take. Many people, of course, would take the opposite option, which would be to intervene, more of a kind of sheepdog mentality. I have the means to defend myself and other innocent people. I have the legal right to do that, the law says, and I'm not going to watch and just let some innocent person be murdered while I did nothing and just stood by. That's also not an unreasonable position, but you are incurring the risks we just talked about. So I don't tell people what to do. I don't tell people to not intervene in other people's fights. I don't tell people to intervene in other people's fights. I just want you to make an informed decision, understanding the risks you're incurring when you do that. All right, so we have the scenario here. Let's see. Let me pull this back up closer to the beginning. This is the scenario you come upon. And you decide you're going to intervene. You draw your pistol, you take the shot, and unfortunately, you put a round through the hostage's head. What happens then? Well, the law actually has a legal doctrine to address this scenario. Looks like YouTube's still running. I can't believe it. And I've just kind of pulled out a more or less random appellate court decision, case law decision, illustrating the legal doctrine we're going to talk about here. It happens to be from Ohio, but every state, this is a common law legal doctrine that's common across the United States. Although some states, especially low population states where not a lot of case law is created, may not individually have applied this doctrine in living memory. So it might have to be argued in those jurisdictions using case law from other jurisdictions, which is not controlling precedent, but is generally influential precedent for a trial court and for an appellate court in a different jurisdiction, especially since everyone who has considered the issue does it the same way. There's really no variance. And the doctrine I'm talking about is, of course, the doctrine of transferred intent. Transferred intent. Now, I'm going to share the court case with you that I've picked out. But in general, what transferred intent says is, that's the case, I'll get to it in a moment, is that if you're intentionally using force against another person, but your force misses that person and hits an unintended person, whatever mental state you had in intending to use that force against person A, that mental state transfers over to person B. So you're as guilty or innocent for having used force against the unintended person, C, as you would have been guilty or innocent as if you'd used that force against the intended person, person B. And here we have this case that talks about this. See if I can make this a little bigger here. And again, this happens to be Ohio, but every state who's considered this question does this the same way. And if they haven't, for some reason, considered the question yet, my full expectation would be when they get their first case involving this legal doctrine in the self-defense context, they would do it the same way as Ohio. Now, every state has covered transferred intent in the malicious context. So you're firing a shot at person B because you want to murder them. That's your mental state. and your murderous bullet misses them and hits an innocent bystander whom you had no intention to hurt at all. You didn't even know they were there. So you had no murderous intent towards the person actually struck. Nevertheless, you're guilty of intentional murder of that unintended victim of your shot, because your murderous intent towards person B, who you missed, that murderous intent transfers to person C, who you struck, albeit unintentionally. So therefore, you're guilty of the intentional murder of C under the doctrine of transferred intent, even though you never intended to hurt them at all. That's how that works. Every state does that. They transfer malicious intent from the intended target to the unintended target. Where states may not have applied the doctrine of transferred intent is in the innocent context, where your mental state in attempting to shoot person B is not murderous, not malicious, but one of justification. You're trying to shoot person B in lawful self-defense. That good intent also transfers over to the bystander. So if you would have been justified in shooting person B, you're also justified in shooting person C, even though they were doing nothing to you. They were no threat, whatever. They were a purely innocent bystander. And this would apply in both criminal and the civil context. Now, there are states that have not considered, or maybe only recently considered, the transfer of innocent intent from one party to the other. They've all done malicious intent. As we'll see here, this court decision from Ohio, it is from 1972, so it's, 50 years old. They say here that this is the first time Ohio is considering the transfer of innocent intent. But when they do it in the same way that every other state does it, which has considered the question. So we have State v. Clifton. By the way, the writing here is quite clunky. It's almost, this must have been a very old judge. Like I imagine most of his decisions were written like in the 40s and 50s. And he's just hanging on until the 70s, but he writes in a very old-fashioned, clunky style. Sorry about that, but it does do a very good job of illustrating this doctrine of transferred innocent intent. So we have Ohio versus Clifton. Clifton. Did they give us his full name? I guess it doesn't really matter. Clifton is the appellant. So Clifton was convicted at trial, of course. That's why we're on appeals. Appeals are for losers. Clifton lost at trial, and now he's appealing his conviction. So we'll get the opinion and we'll get some facts, and then we'll get the application of the transferred intent doctrine. So this is an appeal from a judgment of the trial court in Ohio, entered upon a verdict of finding the defendant guilty of manslaughter in the first degree. For our purposes in the resolution of the issues raised by the appellant, the convicted defendant, the facts may be set forth succinctly. It's not as succinctly as he thinks, in my opinion, but in any case. A youth, 14 years of age, enters a news shop where the defendant was present performing certain tasks for the owner. An altercation ensued between the youth and this defendant. The glasses worn by the defendant were knocked from his face, and the youth got a bloody nose. Well, of course, the 14-year-old ran home and complained to his 17-year-old brother, who grabbed another brother and a friend, James Hargrove, who would be the victim in this case. So these four guys now return to the shop to confront the defendant for giving the 14-year-old a bloody nose. Being forewarned of their return, I'm going to get my brothers and come back here and we're going to kick your ass, I believe is probably what happened. Being forewarned of their return, defendant had taken a pistol from beneath the counter and placed it in the waistband of his trousers, where it was concealed by his shirt. The group of four entered and confronted the defendant. So they're working as a collective group. Right. This will come up later. An argument between the elder brother and defendant developed, which was quieted when the victim suggested the best way to settle the dispute was for the youth to take out a warrant. I guess call the police. Whereupon the four men left the store. Very shortly thereafter, though, the elder brother re-entered with Hargrove. Now there's two. His testimony being that he had to obtain change for his bus fare. So he had an innocent person for re-entering the store, supposedly. It's uncontroverted that while the defendant had his back turned, the elder brother then struck him on the shoulder with a belt, the buckle of which left a discernible mark upon the flesh. So who's the initial physical aggressor here? Well, it's the brother, right? Striking the defendant with the belt. Upon trial, the defendant testified as follows. Quote, I knew I was being attacked by them, so when he hit me, I just drawed the gun and turned around and fired. When the shot was fired, the victim and the brothers were fleeing from the premises. Hargrove, the victim, suffered a wound in his right chest into the abdomen and expired during surgery less than 8 hours later as a consequence thereof. The accused relied upon self-defense as a justification for the homicide, for the killing. He testified that when he fired the weapon, he was in fear of his life or bodily harm. The jury found the defendant guilty of manslaughter as charged in the indictment. Now, I'll pause here for a moment because I think we can see that this is perhaps not the strongest deadly force self-defense argument we've ever seen, right? So the person shot was in flight. Now, was this such a quick reaction by the defendant in firing the shot that he could reasonably have still perceived that he was being under attack, even though the victims were in flight? That can happen. I've seen that happen in cases. And then the victim ends up shot in the back. But it happened so quickly after the victim was presenting as a threat that it's simply a normal delay in reaction time on the part of the person defending themselves. But it rarely looks good when the victim is shot in the back as they're running away from a fight. Also, of course, we have questions about proportionality. I mean, is being struck on the shoulder with a belt a use of force likely to cause death or serious bodily injury? Maybe. I mean, I could make that argument with a straight face. If it is, then a deadly force defense would be appropriate, assuming, of course, the other elements of self-defense are also satisfied. But a jury could reasonably believe that was not a threat of imminent deadly force to buckle. And therefore, there was no deadly force threat. There is no privilege to use deadly force in self-defense. So kind of a sketchy self-defense claim here. The question for the court here is, though, is it possible that a reasonable jury could have bought self-defense as a legal defense if they were properly instructed? And the answer is yes, this court concludes. So it's not for the court to decide whether or not it was self-defense. That's for the trier of fact, a jury in a jury trial or the judge in a bench trial. And there exist facts from which self-defense could be understood to have occurred. So continuing now with the decision, the appellate court says 2 errors have been assigned upon this appeal. The first assignment is that the trial court erred in refusing to instruct as to conspiracy, it being contended that the jury thereby was precluded from considering the act of one, the assailant, to be the act of all in determining whether the defendant acted in self-defense. So this is a good legal defense by the defendant. What he's saying is, look, the person I ended up shooting is not the guy who struck me with the belt. That's awkward. In effect, I hit a bystander, like would have occurred in our hostage scenario, hypothetical. I was trying to shoot the man who'd struck me with the belt. He was who I reasonably perceived as the imminent deadly force threat. But I still should not have legal liability for having shot the other guy who didn't strike me because they were working in concert. They were in a conspiracy with each other, and I was allowed to defend myself against their collective force. So this would be akin to 2 guys are holding your arms so a third guy can stab you. They're all murdering you, even the guys not holding the knife, because they're working in concert to facilitate the knife wielder's ability to stab you. And you'd be privileged to shoot not just the knife wielder, but the guys holding your arms too, if necessary, to defend yourself from that lethal force attack, because they're in a conspiracy. So the defense is saying, listen, I meant to shoot the guy with the buckle, but it doesn't matter because the guy who actually got shot was working with him to attack me. The appellate court, for whatever reason, decides they don't buy this really on an inappropriate basis. They're making factual findings here. They say it's clear from the record that when the accused was struck with the buckle of the belt, there was no plan among the members of the group to perpetuate that act, a conspiracy, a collective attack on the defendant. I don't know about that. I mean, they all came in, 4 initially to have a confrontation, and then 2 came back and attacked, actually attacked. I think a reasonable defendant in that circumstance would perceive both of those men, the actual attacker and the victim, to be working in conspiracy with each other. So this is a matter I would have sent back to the trial court for a jury to decide. Because the jury did not get a conspiracy instruction, right? That's the claim of error here. And the defense is saying, the appellant is saying, listen, if they'd gotten a conspiracy instruction, which I asked for, he did ask for it. If they'd gotten that conspiracy instruction, they might have concluded that, well, if I was justified in self-defense against the buckle wielder, then I was also justified in using the same force against his co-conspirator. But the appellate court decides they don't like this argument. So the first assignment of error is without merit. The second assignment of error gets to our point in today's show, transferred intent. The second assignment of error is that prejudicial error was committed by the trial court in refusing to instruct a jury that a homicide is excusable or justified when one lawfully acting in self-defense kills an innocent bystander by a random shot, if the killing of the assailant would have been justifiable as done in self-defense. So if you're being attacked by somebody and you fire a shot against your attacker, and that would have been lawful, but you miss and the bullet hits a bystander, there's also no criminal liability for hitting the bystander. This is the concept of transferred intent in the context of innocent intent. So your mens rea, your mental state, is a justified mental state, not a malicious mental state. The appellate court notes this exact problem, the application of transferred intent in an innocent mens rea, seems not to have been considered heretofore by any court in Ohio. Basically, the prerequisites to the invocation of the right of self-defense are set forth in paragraph 2 of the syllabus in Martz v. Ohio, a different Ohio case. And by the way, Ohio's self-defense now is codified in statute. So again, this is a 1972 decision. So the general elements of self-defense haven't changed much, except that now Ohio is a stand your ground state, which it wasn't at the time of this 1972 decision. But you'd find it in different form in statute rather than in another court decision. But if we read through this, we'll see we have the elements of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. That decision they're quoting here, quote, homicide is justifiable on the ground of self-defense where the slayer, in the careful and proper use of his faculties, bona fide believes and has reasonable ground to believe that he is in imminent danger of death or great bodily harm, and that his only means of escape from such danger will be by taking the life of his assailant, even if he is mistaken as to the existence or imminence of the danger. So we have, let's see. Yeah, so the other party is the assailant, the initial aggressor. So the defender has the element of innocence. He's facing an imminent danger, so he has the element of imminence. That danger is death or great bodily harm, so that's proportionality. That's what privileges you to use deadly defensive force. Avoidance is touched upon here. His only means of escape from the danger would be by the use of deadly defensive force. So if he had another means, like running away, he'd be obliged to use that. At this time, Ohio was a duty to retreat state. It is not any longer, folks. It is a stand your ground state. In fact, it's a hard stand your ground state today. And then the element of reasonableness has two components, right? A subjective reasonableness and objective reasonableness. Subjective mean you had a genuine good faith in your need to use that force in self-defense. That's what they mean here when they say that the defender had a bona fide belief in the need to defend himself, and he had reasonable ground to believe that subjective belief was objectively reasonable, that these other elements had been met. So those are all the elements of self-defense here, as we always find them in every American jurisdiction. Then there's this is a textbook, basically, Ohio Jurisprudence, Homicide, Section 89. They're quoting from an authoritative textbook on Ohio homicide law. Quote, it is universally recognized that one is not punishable criminally for taking the life of another person when he has been put under the necessity or apparent necessity. You don't have to be right in self-defense. You don't have to make perfect decisions in self-defense. You have to make reasonable decisions in self-defense. If you reasonably perceive, but mistakenly perceive, but reasonably perceive a deadly force threat, that would be sufficient for self-defense. when he's been put under the necessity or apparent necessity of doing so without any fault on his part, there's innocence. In order to protect himself from the peril of death or serious bodily injury, there's proportionality at the hands of the person whose life he took. Close quote. Now, continuing with the opinion here, clearly one who kills in self-defense does so without the mens rea, the mental state, that otherwise would render him culpable, legally liable for the homicide. Therefore, if the act of taking the life of an assailant is not criminal, does it become criminal when a stray shot kills a bystander? That's the question. Now they look at transferred intent with a malicious mental state. It has long been accepted that if A shoots at B intending to kill B, but instead, and they mean without justification here, but instead the bullet strikes C, then A has committed a criminal act as to C. In such instance, the malice follows the blow, and the criminal intent of A to harm B is transferred to C. However, if A had no criminal intent with respect to B, as where A is exercising a lawful right of self-defense, none could exist as to C either. It follows then that A, in shooting C, has not committed a criminal act. The essential mens rea, mental state, the malicious mental state, being impossible of proof, meaning it doesn't exist. It was lawful self-defense. The inquiry must be whether the killing would have been justifiable if the accused had killed the person whom he intended to kill, as the unintended act derives its character from the intended act. Therefore, we conclude that the second assignment of error, the failure to give this transferred intent instruction to the jury, is well taken. The jury was fully and correctly instructed as to the law pertaining to the asserted right to self-defense. However, the court erred in refusing to include an instruction that if the jury found the accused was acting in self-defense when he fired the shot that killed the victim, he would be entitled to acquittal even though the victim was not the assailant. It is conceivable that from all the evidence and in obeying the instructions of the court, the jury believed that the defendant did prove self-defense as to the elder brother who actually attacked him, but because of the absence of the transferred intent instruction, they could not find the homicide of the victim to be justifiable. So the judgment of the trial court is reversed and the case is remanded for a new trial. Judgment reversed and case remanded, and this was a unanimous 3-judge panel decision. And that's how transferred intent works. If your mens rea, your mental state, is a lawful mental state when you're facing that hostage situation, let's see, as here, if you have the lawful, justified mental state in firing the shot at the hostage because you're acting in lawful, justified defense of this woman, and you unintentionally strike and kill the woman, that good intent transfers over to the bullet that struck her, and there's no criminal liability for her killing. Now, of course, when I say that, that is the legal doctrine of transferred intent, of innocent intent. That's what your defense lawyer would argue. That's what the courts should uphold. But remember, there's noise in the system, in the criminal justice system. So there's never a guarantee that your argument will be successful. And by the way, the case we just looked at, it could go back to trial and the jury could say, well, we don't think it would have been self-defense to fire the shot at the assailant. And therefore, there is no self-defense as to the unintended victim. That could be the outcome of a retrial. So we don't know that that appellant was successful on retrial. We only know that the jury should have been given the opportunity to have heard the argument, the transferred intent argument. All right, so that's how transferred intent works in the context of an innocent intent. And YouTube is still running. I am impressed. All right, so folks, we are now at the Q&A portion of today's show, which is where we end the public stream of our shows. Q&A is only for Law of Self-Defense members. We do that over at the Law of Self-Defense member live stream, where we have our own chat function over there. The good news is it's easy to become a Law of Self-Defense member and cheap. You can have a 2-week trial membership for just 99 cents. Sign up at lawselfdefense.com/trial, and you'll be instantly emailed the instructions you need to join us for the rest of the show and every other members-only content we produce. 99 cents, folks. And after the 2-week trial, it's still dirt cheap being a Law Self-Defense member. It's only about 30 cents a day, less than $10 a month to be a Law Self-Defense member. But at least try it out for 99 cents. I mean, come on. At lawofselfdefense.com/trial. Now, if you make the unfortunate decision not to join our community, that's up to you. But that means that the show is ending for you here. So if you're on Twitter, if you're on YouTube, if you're on Rumble, we wrap things up now. I hope to see you all again soon. If you're a Law Self-Defense member, don't go anywhere. I'll be back in about 20 seconds.